Administrative law, states, tortious and contractual liability, lecture 7. Dear student friends, I am Dr. Rega Surya, Principal, Aided Law College. Today, I wish to take up Administrative Law, lecture 7. In this lecture, I wish to take up tortious liability and contractual liability of state or government. Dear friends, I have already told you, administrative law is part and parcel of constitutional law. Most of the topics from administrative law are relevant to constitutional law. So, whatever topics you studied in constitutional law will be repeated in administrative law. Similarly, some topics which you studied in administrative law would be repeated in constitutional law. For example, in administrative law, I selected our most important topics or most important questions, 9 topics. There are about more than 14 topics or 14 chapters in administrative law, out of which I have selected 9 topics or 9 questions which are very important not only from examination point of view but also from practical point of view. In first two lectures, administrative law, lecture 1 and lecture 2, I explained about the subject in brief as a whole, all the 9 topics in brief. In first two lectures relate to summary of the subject in brief. Third lecture, I explained in detail about two important doctrines, doctrine of separation of powers and doctrine of rule of law. These two topics will be repeated in constitutional law also. Next, fourth topic, I complete in fourth lecture. I discussed in detail about the principles of natural justice, rule against bias and ad alteram partem, the rule of fair hearing. In next lecture, fifth lecture, I explained in detail about first two lectures, administrative law subject as a whole. Third lecture, the rule of law and separation of powers. Fourth lectures, I explained about natural justice. Fifth lecture, I explained about ombudsman. Sixth lecture, I completed public interest litigation and locus standi. This is seventh lecture. In this lecture, I want to complete state liability or governmental liability or contractual liability and state liability of the government. These contractual liability, Article 300 of Indian Constitution deals with tortious liability. Article 298 and 299 deal with contractual liability. Article 298, 299 and 300, these three articles deal with contractual liability and tortious liability of state. These topics will be repeated in constitutional law also. So earlier administrative law was a part and parcel of constitutional law. In 20th century, it was conferred independent status when the government conferred some judicial powers on executive bodies, tribunals. The tribunals are executive authorities while discharging their duties, exercising their judicial power conferred on by them. If any irregular arbitrary decisions are given in order to protect the interest of the aggrieved, the administrative law started development since 20th century. This administrative law witnessed tremendous growth and development. So these two topics, tortious liability of the state and contractual liability of the state, we have to discuss in this lecture. Dear friends, firstly I speak about tortious liability of the state and then I proceed to contractual liability. Tortious liability of the state, this topic I explained in detail in my law of torts lectures under the head state liability. Under the state liability, I explained about the tortious liability of the state in detail. Anyway, for the purpose, I request you to refer my lecture on tortious liability, state liability in respect of torts committed by its servants from torts lectures for elaborate information. Anyway, I will explain about this tortious liability of the state in brief. So, a government or state discharges various functions for the welfare of the people, for the well-being of the people through the agency of its servants, government authorities, that is, government servants. So, all governmental functions are discharged by government servants. Government servants are also known as public servants, civil servants, or state servants. Those employees and officers who are working under pure central government or state government or union territories under the central government are regarded as government servants or public servants or civil servants. But the others, though they are enjoying the privileges on par with salaries and other benefits on par with government servants, in some cases more than government servant fringe benefits, they cannot be treated as government servants. For example, the general managers, chief managers of nationalized banks, topmost officials of life insurance corporation, food corporation, and others, they are not government servants. Even topmost official in state bank, he is not government official, government servant. Government servants are even a class 4 employee working in pure central government or state government. They are treated as public servants or civil servants or government servants. The reason is the public servant or civil servant or government servant enjoys some special privileges and immunities. See, if any disciplinary action is to be taken against a government servant or civil servant or public servant, some lot of procedure is there. When a disciplinary action is to be taken against a government servant, a notice of 2 months is to be served against him. Why action should not be taken against you? So 2 months notice is to be served under section 80 CPC. Secondly, the public servant is provided constitutional defense under Article 311 Clause 2. So, after a disciplinary action, he must be given reasonable opportunity. First notice is given under Section 80 CPC. Thereafter, he is given proper opportunity to explain, to prove that why that he is innocent. No disciplinary action should be taken against him. So, directly a disciplinary action cannot be taken. Firstly, 2 months notice under section CPC is to be given. Secondly, constitutional protection is to be given. But the other employees, Government of India undertaking employees, nationalized banks employees, private bank employees, and others, there may be giant organizations, steel plants, shipyards, though they are Government of India undertakings, the nationalized bank, though they are Government of India undertakings, disciplinary action can be taken against them without serving a notice of 2 months or providing article constitutional defense under Article 311(2). Of course, if any bank employee is removed or retrenched from service, or any bank officer is there, any action is taken, they are associated with some registered organizations, employees association, officers association, and other. So those bodies will protect. If any action is taken against that particular officer or employee, they will start strike and create disturbance. So they will threaten the government. They will demand reinstatement, and thus in that way that particular employee may be protected, of government of quasi-governmental official may be protected in other ways. But constitutionally speaking, the general manager of a government of India undertaking can be terminated by the chairman and managing director of that particular organization without assigning any reason. So there is no protection. But with reference to 2 months notice, immediately the notice of 2 months can be waived by with prior permission emerging in some exigencies and contingencies with prior permission with prior permission of the concerned authority which is competent to take disciplinary action against that particular public servant. So this is the position. So when government is discharging, government servants are discharging duties on behalf of the government under the principle of vicarious liability. If you refer my lecture on vicarious liability, you will have. There are several instances of vicarious liability. Vicarious liability in the sense one person performs work on behalf of another. That is, if one person performs work on behalf of another and the latter commits any wrong, that wrong is deemed to have been committed by the farmer. Suppose lorry owner appoints one driver, and driver commits accident, then the owner is liable. The owner is liable. So the liability is for civil liability only, not for criminal liability. We are going to discuss all these points one by one. So now coming to the next point. The principle of vicarious liability. There are so many instances of principle of vicarious liability. Employer and independent contractor, firm and partners, master servant, like this. So when government servants are discharging duties on behalf of the government, some wrongs may be committed. While discharging duties, the government servant might commit some wrong. That wrong may be too serious. The wrong may be crime or public wrong or private wrong. So when a public servant or civil servant renders services, discharges duties on behalf of the government, some wrongs may take place. For those such wrongs, the government is to be held liable under the principle of vicarious liability. So here, before, what is the wrong? What is the nature of wrong? So the wrong committed may be public wrong, that is crime or offense. The word offense is used in all general legislations and special legislations of the criminal law, IPC, CPC, CR, IPC, Indian Penal Code, Criminal Procedure Code, Dowry Prohibition Act, Prevention of Corruption Act, and all special legislations. The words offense is used, but public wrong or crime is not used. So other than the public wrong or crime or offense, all the wrongs are called private wrongs. All the wrongs are private wrongs. So these private wrongs are, all public wrongs or crimes or offenses are tried in criminal court. That is why they are called offenses and crimes. But the remaining all the remaining wrongs are called private wrongs. These private wrongs are tried in civil courts only. Only public wrongs or crimes or offences are tried in criminal courts. They are crimes or public wrongs. All the remaining wrongs are private wrongs. Private wrongs are tried in civil courts. That is why private wrongs are also called civil wrongs. Civil wrongs. Now we discuss about in crimes, pickpocketing to murder, gang rape also. Pickpocket is the smallest crime, smallest crime, gang rape, murder. They are serious crimes, sedition and others. So they are serious crimes. How there is a smallest crime and highest crime. Similarly, in private wrongs also, highest civil wrong and lowest civil wrongs are there. So the next top level civil wrong is tort. The tort is next to crime. Tort is next to crime. Tort is next. Tort is a civil wrong. Tort is how in crime it causes serious injury or damage to human body or human property or human reputation. But this tort is such a serious. So there is a causal connection between tort and crime, which I explained in detail in my torts class. So now, for example, defamation is defaming another person is a tort as well as crime. For defamation, for when A defames B and B can file a case against A for defamation. This defamation is tort and crime. Crime in the sense B can file a case against A for A's punishment under section 499 IPC. That is more serious. And B also can file a case against A for compensation. Depending upon his social status, he may claim a relief under tort. B may be put to tortious liability for lakhs or thousands or lakhs or crores according to the total status of the B. So next to crime, it is tort. So tort is a civil wrong. Tort is one kind of civil wrong. There are so many civil wrongs: breach of contract, breach of trust. Breach of trust is tort and crime. Breach of quasi-contractual obligation, like that. Among the civil wrongs, the highest civil wrong is tort. Next to crime, tort is there. So when the government servant commits a wrong, if that wrong is a crime, the government is not liable, he himself is liable. Suppose if he commits any crime like murder, rape, whatever it may be, custodial rape or anything, then he himself is liable, a disciplinary action will be taken. So because in criminal law, vicarious liability is unknown to criminal law, but the master is not held liable for criminal liability of his servant unless he is abettor. If the master is consented to with reference to that claim, then only master can be held liable, equally liable, like an abettor. This abettor topic I explained in detail in criminal law also. So now coming to the point, he taught when the wrong committed by government servant may be a crime, like it may be corruption, or it may be cheating, it may be any other crime, any other crime, sexual harassment of his subordinate woman employee, rape, or whatever it may be. But he himself is liable. Disciplinary action will be taken by the government, and government is nowhere responsible. Next, tortious liability and civil liability. Tort liability means if the wrong committed by public servant constitutes tort, when government is liable, when government is not liable will be the question. Suppose the contract, breach of contract, if the wrong committed by public servant amounts to breach of contract, when government is liable, when government is not liable, that is the question for discussion. Now we have to discuss about when government is liable for torts committed by the servant, when government is liable for breach of contract by the breach of contract committed by the servant. So this is the position. We have legislation since 1872. Prior to that, Crown charters and other so many things are there. We studied in constitutional history. Now coming to the even though we have legislations, Indian Contract Act 1872, Indian Evidence Act 1872, when government is liable, when government is not liable, there is no any law. Before 1947, 1885 in England, the king was not liable. Before 1947, that is before the passing of the Crown Proceedings Act, the government or state was exempted from criminal liability, exempted from civil liability, that may be tortious liability and contractual liability. So there was no civil liability, whether it was a breach of contract or tort committed by the servant. If government servant committed tort or the government servant committed breach of contract, if third party suffered injury or loss or damage, if that third party, aggrieved party, filed a case against the government or state, the king was not liable. There was on the ground that the king enjoyed sovereign immunity. The king is not answerable in his court. That is what is called king can do no wrong. King can do no wrong. The king is not answerable in his own court. So the state was not liable. The government was not liable. If any government servant committed breach of contract or tort, government was not liable because that exemption was called sovereign immunity. So the king or state was exempted from liability, tortious liability or contractual liability committed by the servant on the ground that king was sovereign, state was sovereign. So king or state exercises sovereign power. That exemption on the ground of sovereign was called sovereign immunity, exemption from liability. So on the maxim, king can do no wrong, because in view of explosion of population and governmental activities have been increasing day by day. So this exemption, sovereign immunity, could no more be possible. That is why in England, Crown Proceedings Act was passed in the year 1947. In England, Crown Proceedings Act was passed in the year 1947. According to the Crown Proceedings Act, the state or government is liable like any ordinary individual for the tort committed by the servant or breach of contract committed by the servant. That was the position. So here, but in England, Crown Proceedings Act was passed. It prescribes the liability of the government or state, when liable, when not liable. But in India, we don't have any law. We are following only traditional rule coined by Chief Justice Peacock in the year 1860 in Peninsular and Oriental Steam Navigation versus Secretary of State for India. So in England, one case was reported. In that case, P&O Steam Navigation was Secretary of State for India. There is a rule, sovereign and non-sovereign dichotomy. In P&O Steam Navigation case, the facts I have given in torts class, you please refer. According to that, what is sovereign power, what was not sovereign power was discussed. Those powers which can alone be done by state or government are called sovereign power. Which can be undertaken by any other private body, they are non-sovereign powers. For example, Army, Navy, Air Force, Police, Judiciary, these are the sovereign powers. Government or state alone can discharge such functions. But postal railway, transport, shipping, transport, these roads, building, construction of roads and building, these are commercial functions. So they can be done not only by state but also by, we are seeing these transport services in government sector, transport service in private sector, communication in that is post and telegraphs in government sector, courier in private sector. We are witnessing today so many some commercial activities are in private sector and government sector, side by side we are doing. But in that P&O Steam Navigation was Secretary of State for India, Chief Justice Peacock, then Calcutta High Court Judge, Chief Justice coined a rule, sovereign and sovereign. If the powers are sovereign, government was not liable. If the if the discharge of power is non-sovereign, government is liable. In that way, he decided in that case. We are following that sovereign non-sovereign dichotomy. When state is liable, when state is not liable. If government servant while discharging the duties on behalf of the government, if any tort is committed, if then government is not liable. When government is not liable, the government servant was discharging the duty, discharging his duty on behalf of the government. So discharge of duty is under sovereign delegation. What is sovereign, what is non-sovereign, there is no any test. But as I told you now, those functions which can alone be done by government or state are called sovereign function. Those functions which can be undertaken by any other private body are called non-sovereign functions. Sovereign means Army, Navy, Air Force, Police, Judiciary, etc. They are sovereign powers. Shipping, transport, roads, buildings, communications, postal, telegrams, they are non-sovereign functions. So, if the government servant while discharging Army, Navy, Air Force, Police, etc., it was considered sovereign. If it is postal or courier, railway, it is non-sovereign, like that it was discussed. Because of this non-sovereign sovereign non-sovereign dichotomy, so many irregular judgments were given in Tulsi Ram case, Tulsi Ram versus state of Uttar Pradesh. Some judgment was given wrong on the ground of sovereign non-sovereign dichotomy. The government was protected, Uttar Pradesh government was protected. Kasturi Lal case also, the government was protected. State of Uttar Pradesh was Tulsi Ram also, the government interest was protected basing on the sovereign non-sovereign. But when the government was attempted, when there was an attempt to protect the government interest at the cost of an innocent, in Vijayavati versus state of Rajasthan, an attempt was made to protect the interest of state to deny the compensation to an innocent woman widow. In that particular case, Vijayavati's husband met with an accident. They met with an accident, and when the widow when they approached the court for compensation, then in Rajasthan High Court followed the 1860 sovereign non-sovereign dichotomy, and they tried to dismiss the case and protect the state government. When appeal was preferred before the Supreme Court said, see, when an innocent woman having lost her husband who was knocked down by government vehicle approaching the court for compensation for her livelihood, it is very absurd, indecent to draw a line between sovereign non-sovereign without referring anything. Chief Justice Sinha directed the Rajasthan government to pay compensation to the aggrieved. But in spite of several cases, in spite of Vijayavati's Chief Justice Sinha's remarkable judgment, landmark judgment in Vijayavati's case, the position is not clear, but there is no law. There is no law in India except Article 300 of the Indian Constitution. Article 300 of the Indian Constitution makes provision for liability of the state for the torts committed by the servant. But there is no any act. But the Supreme Court suggested the Law Commission, recommended the Law Commission to pass legislation on state liability or government tortious liability. When government is liable for torts committed by the servant, when government is not liable for torts committed by the servant, for that purpose, in legislation must be passed. To that effect, a bill was presented, government liability in tort bill 1967 was presented in Lok Sabha, but it has not yet been passed into law. So there is no proper law. In India, there may be hundreds or thousands of legislations right from 1860, but in so many areas there are no laws. In so many areas the law is not clear. So many subjects are not codified. For example, administrative law is not codified, environmental law is not codified. Environmental law constitutes more than 200 legislation, but the environmental law as a whole is not codified. Torts is not codified. Tort is supported by in law of torts. So many piecemeal legislations are being applied, but there is no law of torts as a whole. General law legislation tort is not there. So here, this is the position. So now, when state government, when government servant or civil servant, public servant commits a tort while discharging the duty, the state is liable if a state is liable provided two conditions are satisfied. If the tort is committed by servant while discharging his duty and within the color of his office. Secondly, the discharge of such duty must be under sovereign delegation. This is also subject to inherent jurisdiction by the judges, because the under section 148 to 151A of the Civil Procedure Code, the judges of civil courts are conferred inherent justice. Article 226 confers on High Court to deliver judges judgment of their own. Article 32, Article 136 confer on Supreme Court judges to give the judgment of their own. They can give the judgment of their own which they find fit, which is the justice, in the interest of pure and impartial justice, in order to provide relief to the aggrieved. The judges are given discretionary power irrespective of law, irrespective of what is contained in law. So that is why though there is in India, and with the help of we have judicial activism. With the help of judicial activism means anxiety and excitement of courts to to deliver pure and impartial justice. In an attempt to deliver pure and impartial justice, the judges of the lower courts and apex courts, High Court and apex court, Supreme Court, are provided or vested with some special power, that is inherent jurisdiction or review power to deliver the judgment of their own which they consider fit. Such an activity of the judges, such an anxiety or excitement of the judges to deliver pure and impartial justice in the absence of law, in the absence of legislations, in the absence of even though the legislations are there, the legislation is not clear. For example, basic structure. What is basic structure? There is no any clarity. But the Supreme Court, the court can give its own clarification. So, what is the basic structure? There is no any definition. There is no any test. It varies from case to case and situation to situation. This is the position with reference to state liability. So, when the state is liable for torts committed by the servant, technically speaking, Article 300 of the Indian Constitution provides for the liability of the state or government for the torts committed by the servant in discharge of the duty. To the state or government to be held liable, two conditions are to be satisfied. Number one, the tort must have been committed by the government servant while discharging his duties, and that is in color while acting in color of office. Secondly, the discharge of such duty must be under sovereign delegation. That may which refers to Army, Navy, Air Force, police, judiciary, such vital powers which can alone be discharged by the government only. If even though the state, the tort is committed by the servant in discharge of duty or obligations imposed on him by law, if it is a non-sovereign, if it is like roads, building, shipping, transport, postal, etc., railway, it is not sovereign. The state is to be held liable for the torts committed by the servant. So, for more details and more case law, dear friend, you may refer to my lecture on tortious state liability, that is wherein I explained in detail about tortious liability of the state in law of two lecture. Now, today, the second most important topic for discussion is contractual liability of the state. Contractual liability of the state. Article 298 and 299 of the Indian Constitution provide various provisions relating to contractual liability of state or government. According to Article 298 of Indian Constitution, every state, whether it is central government or state government, union government or state government or union territory, they are empowered to carry on trade and business, which must be legal. Generally, when government carries on any business, it must be absolutely legal. There is no question of any illegal business. So here, according to article, now the main heading is contractual liability of the state for the breach of contracts committed by the servants. Whether state government servants or central government servants, they attend so many contracts on behalf of the government. For example, so many states are welfare states. So the government to establish welfare state takes up so many welfare programs for the benefit of the people. So here the governments are providing free rice and essential commodities. For that purpose, for the supply of rice, wheat and other provisions, the government through the servants may enter into contracts with some private parties and contractors. The government provides house scheme. Then the governments enter into builders for construction of houses to the people, poor people. Like that. When government wants to enter into contract, the government cannot enter into contract directly with government servants, the collectors, secretaries, directors, and all the people concerned attend contracts on behalf of the government and on behalf of the government servant attend contracts with third parties, builders, suppliers and other traders and manufacturers for those contracts are called contracts entered into between government and third parties. So when government wants to enter into contract with third parties, the government servants will enter into contract. So that is why Article 298 of the Indian Constitution makes provision that every government, whether it's state government or central government and union territory, is authorized or empowered to carry on trade, to do any business. That is one thing. Secondly, Article 299 Clause 1 empowers that, tells that when any government contract, central government contract is to be entered into, it must be entered into in the name of the President of India. A President of India, for President of India, and the concerned officer authorized. He may be collector, he may be secretary, he may be chief director, he may be a controller and auditor, or who, whatever it may be, who enters into contract. For President of, suppose I am central government employee, I enter into a contract, I am the secretary of union government, for example. When I enter into contract for President of India, secretary, as a joint secretary, so and so, that name should be there. So then when the government, according to Article 298 of the Indian Contract Act, every government, central government, state government and union territory is authorized or empowered to enter into contract with the third parties for the purpose of public service. So that is one. Secondly, the contract must be entered according to Article 299 Clause 1. The contract must be entered into on behalf of the President of India, if it is central government contract, by the competent official. He may be collector or secretary or whatever may be. The third point is the contract must be the contract, Article 299 Clause 2, but though the contract is entered into on behalf of a President of India or Governor of the state, according to Article 299 Clause 1, if it is union government contract, it must be entered into on behalf of the President of India, for President of India, then first for President of India, Union Secretary, like this. And if it is a state government contract, for Governor of Andhra Pradesh, for Governor of Himachal Pradesh, for Governor of Uttar Pradesh, for Governor of Madhya Pradesh, like that, and in that collector so and so, or chief secretary so and so, like this. So if it is according to Article 298, every state government, central government or union territory is authorized to carry on trade and business. Secondly, according to Article 299 Clause 1, if it is a central government contract, it must be in the name of the President of India by the concerned competent authority officer. If it is a state government contract, it must be on behalf of the governor of that particular state by the competent authority, competent officers. Third one is according to Article 299 Clause 2, when the contract is entered into on behalf of the President of India or Governor, either President at central level or Governor at state level, there is no any special personal liability. It is only official liability only. That is second. Article 299 Clause 2 tells you. Next most important thing is, when a contract is entered into by between government and third party, it must be a valid contract within the meaning of Section 10 of the Indian Contract Act. So whenever, what do you mean? Section 10 of Indian Contract tells that if the contract is entered into between two competent parties freely consented to enter into an agreement not declared void for lawful consideration, and is not prohibited by law. If is not forbidden by law within the meaning of Section 25 of the Indian Contract Act, that there should not be any, we must not oppose the public policy from Section 26 to 30. So this is when two competent parties freely consented to, two competent parties, Section 11 and 12, freely consented to Section 2D, enter into an agreement not declared void by void, Section 25, not subjected to 26 to 30, and for lawful consideration 2D, and lawful object, and for lawful object or legality of object, that is Section 25. That contract is said to be lawful contract. So here, when Section 20, according to this, a government contract contains these conditions on behalf of the government of President of India by the concerned official, if it is a state government contract, on behalf of the governor of the state by the concerned official. Secondly, it must be a valid contract within the meaning of Section 10 of the Indian Contract Act. So, as far as these principles are concerned, government contract must be strictly adhered to all these contracts. So, in government, this also prior to Crown Proceedings Act 1947 in England, breach of contract is committed by government servant. Government is not liable. After the passing of Crown Proceedings Act 1947 in England, the government is liable. But in India, there is no any law legislation to that effect. But Article 298 and 299 provide for contractual liability of the state for the breach of contracts done by the servant. So here we are telling that the contract, when government contract, state government or central government contract is entered into with third person, it is very 299 clause 1 is very essential. It must be on behalf of the president of India if it is central government. If it must be on behalf of the governor of the state if it is state government contract, by the appropriate authority, appropriate collector or secretary or whatsoever may be, that is there. So even though if it is done even though the formal contract is not completed, still the state is to be held liable. State is to be held liable. There is a relevant case on this point. There is a relevant case, Union of India versus AL rule here wrong. In this particular case, so this is central government contract. In this contract, every formal contract is finalized on behalf of the President of India. It was entered into by Chief Director of Purchase for procurement of some cigarettes. They called for they called tender. They received so many quotation. One quotation was finalized, and the party whose quotation was finalized supplied the material but could not get the payment. He filed a case for recovery, but it was said that the government tried to escape on the ground that there was no formal agreement. Formal agreement was not finalized, but it was found in this particular case that Supreme Court made it very clear. The contract has been entered into between the Chief Secretary on behalf of the President of India with the plaintiff. That is enough. If the formal agreement is not is immaterial, even it can be, if it is oral agreement is made, it can be done. When once it is, if it is done on behalf of the President of India by the appropriate competent authority, it is enough, and the government was held liable. So, for example, if it is not on behalf of the President of India, and the formal agreement is finalized, then the government is not liable. It was laid down in Mulchand versus State of Madhya Pradesh. Mulchand versus the State of Madhya Pradesh. In this case, what happened was, in this case, the court, in this case, the agreement, everything is done, but on behalf of the governor was not there. On behalf of the government was not there. That was why it is. So here, it is most important that Article 299 Clause 1 is very important. If it is central government contract, if it is a central government contract, on behalf of the President of India must be there by the competent authority, competent official. If it is state government contract, on behalf of Governor of India, by the competent officer. So we have we are so many: Visakhapatnam Steel Plant, Hindustan Shipyard Limited. For Hindustan Shipyard Limited, managing director. For Hindustan Shipyard Limited, chief manager personnel, like this. So for President of India, managing director so and so company. For governor of Andhra Pradesh, for governor of Madhya Pradesh, so and so managing director, chairman and managing director, like this would be there. So that stamp is most important. Even though formal agreement is not done, it is okay. But if that president or governor, the terms is not used, and formal agreement and everything is done, the state is not liable. So when once the government, if it is done, the party, there is, according to section, if there should not be any defect in the government contract, if any defect is found, the aggrieved party can repudiate the contract and can get back the amount. It was according to section 65 of the Indian Contract Act. According to section 65 of the Indian Contract Act, the irregularity, a void contract is entered into unknowingly that it is a valid contract. Subsequently, it is found that it is a void contract. then the contract can be repudiated by the aggrieved party. The amount paid, if any, from either of the parties can be recovered. That is what section 65 tells. Dear friend, in this particular lecture, I have completed two topics. That is state liability, contractual liability of the state, Article 298 and 299 of the Indian Constitution, Article 300, tortious liability of the state or government under Article 300 of the Indian Contract Act. So, Article 298, 299, 300, all these relate to constitutional law. These topics will be repeated in constitutional law paper 2. So this I am completing this administrative law for the reason it serves the purposes of two subjects. Constitutional law and administrative law is one reason. Second reason is these topics are not only important from examination point of view but also from practical point of view. So dear friends, let us all pray God, let us all pray God sincerely day and night to get us liberated from the clutches of this global menace coronavirus. As a matter of fact, my mind is not all the Indians, all the people at the go at global level are not happy, but we are in a lot of tension. In spite of that, to forget the tension, to forget this problem, to have some mental relief at this time, so that I am delivering these lectures for the benefit of the students. Let us all pray God that we will be happy with the earliest started span. We are very comparatively we are better when compared to other states. I tell you, dear friends, you please watch my channels regularly. So my lectures will be very useful because I am delivering lectures subjects wise and in shortest span, more volume and I am presenting. So in this that is my so every topics there are a number of pages are there in books. I have reduced the huge number of pages to limited number of pages in my book. I am converting the very limited pages into too little volume into my lectures. If you can possess this much knowledge, this will be more than enough. This will be more than enough. Wow, how more you have prepared is not important. How much you remember, how much you presented in examination is more important. So I sincerely suggest that my lectures are not only useful for law students but also useful to lawyers and junior lawyers and lecturers. If the advocates who wish to know about a particular subject which he forgot and wanted to do, he may first listen to my lecture and then will refer any book of his choice as per his standard and competence. And similarly, teachers, if they forget any subject and that subject he is asked to teach, if he follows my lectures and then prepare any books of his level, then it will be easier for you. So I am ready to learn anything from my, suppose for example I tell you, we are elders, we are law graduates, post graduates, lawyers and everything. You let us see one second standard book, English medium or Telugu medium. You read all the book. Absolutely, some of the points we don't know. We don't know. If you read second standard book, that second standard student knows, but we don't know. But that is there are important point not only for that student but also for our personal life also. That is why nobody is there in this world, nobody is there in this universe who knows everything about something. So what we have knowledge is very limited. Kindly communicate my lectures to, in spite of this critical situation, I am also in lot of tension, but to forget my tension and I can forget about this. There are two benefits. I can forget this corona tension, and secondly, I can my lectures can be useful to my future friends. That is why I am doing this job. Never think that in spite of this corona problem, this Rega Surya Ravi is delivering lectures. He does, whether he doesn't have such fear like that. Don't think. I have a lot of tension and lot of fear. I am sincerely, honestly praying God every day, relieve our people at a global level to get freed from the clutches of this global menace. Thank you very much, dear friends. May God bless you. I wish you all success. Thank you very much for your patient hearing. I once again salute my student friends with folded hands to for your consistent and unstinted help and growth, help and help. Without you, this Raga Surya is no more in the minds of legal learners. Thank you very much.